All right, so I think we're going to go ahead and get started. All right. Hello, good morning. Welcome to the Initiative to End Family Violence's first annual conference, the Politicization of Safety. So whether you traveled from across campus, across the county, or across the country, thank you. We are so glad that you are here, and I know many of you experienced extensive travel delays yesterday, and so we are thrilled to be here today in sunny Southern California all together for this conference. I'm Jane Stover. I'm a professor at the law school here at UCI, where I direct our domestic violence clinic. I'm also the director of the UCI Initiative to End Family Violence, which is an on-campus endeavor that unites faculty from over 20 different departments in different research, education, and clinical interventions in family violence across the lifespan. And as we're working on this complex problem of family violence, it's incredibly important that we think critically about issues of intersectionality, about how we conceptualize gender violence, about various state interventions in family violence and gender-based violence, and about state violence itself, as we recognize that the state has not been a neutral vehicle for reform. And today's panels will critically explore the political dimensions of and the movement politics regarding interventions in or failures to intervene in domestic violence. Now, domestic violence is commonly assumed to be a nonpartisan, bipartisan kind of an issue, that what legislator doesn't want a topic, kind of a headline saying they are working against domestic violence. This sometimes leads to the enactment of some not so well thought out, not so survivor-centered policies, right? And we know that racial and gender politics, that the move toward criminalization, reproductive justice concerns, gun safety questions, and other political interests do shape responses to domestic violence. And this phrase, the politicization of safety, has multiple meanings and dimensions. And so we're, of course, examining politics in the more obvious partisan sense. And we can look at different legislative battles to illuminate growing divisions while surfacing values motivating different policies. We'll also be exploring politics and tensions within the anti-domestic violence movement and evaluating this movement's position in relation to other social issues and progressive concerns. We know that the feminist movement has championed unity and equality, but it's also been marked by tensions and fractures. And differing perspectives and alliances naturally influence different policies and practices. And the politics of advocacy and the narratives surrounding victim survivors also are implicated. And in formulating this theme of the politicization of safety, we're also driven by the idea that maybe we're here at a university, that maybe based on research, there are some issues that just shouldn't be so divided along party lines, that we don't need further congressional hearings for, that opposition might seem irrational based on our country's justice, safety, and autonomy principles. For example, we know that research shows that firearms in the hands of domestic abusers increase the likelihood of homicide fivefold. Yet as more public massacres occur by armed gunmen, yes, my gendered use there is intentional, almost all of whom have histories perpetrating domestic violence, gun safety measures that are desired by a majority of Americans, including a majority of gun owners and a majority of NRA members, still aren't passed by Congress. The National Rifle Association instead wants more guns in the hands of more Americans, refusing to acknowledge the problem with such easy access to rapid-fire, high-lethality weapons. In other areas that doctors, we know, commonly advise patients about different health topics. And I'm sure we're each asked questions about how often we exercise. The extent to which you answer is true is okay with, you can tell, I might exaggerate a little there. But doctors ask about exercise. They ask about alcohol intake, about smoking. It also makes good health sense to ask about domestic violence and weapons in the home. Nevertheless, states began enacting gag orders on doctors to prohibit them from asking about guns in the home. We recently needed a federal court of appeals to rule on doctors' First Amendment rights to even inquire about the presence of guns in the home, to be able to advise patients about safe storage practices. In terms of the role of data, one other example is the extensive research showing that intoxication plays a significant role in campus sexual assault, as Donna Coker has so powerfully noted. And so maybe it would be sensible to pay attention to alcohol in our education and prevention methods and efforts. And a prime example of the politicization of safety was a legislative battle regarding the most recent reauthorization of the Violence Against Women Act. So first passed in 1994, this landmark federal legislation recognized the scourge of domestic violence, created new legal remedies, including immigration remedies for qualifying abuse survivors, and authorized multiple grant funding programs. After we had several bipartisan reauthorizations, during which the remedies just seemed to improve and become more expansive, VAWA became a source of contention between political parties. During 2012 and 13, VAWA expired for over 500 days due to U.S. Senate and House differences over whether VAWA would include the protection of Native American abuse survivors, require college campuses to develop policies to respond to sexual assault, and prohibit discrimination against LGBT abuse survivors. These protections really shouldn't serve as hot-button flashpoints, but rather, I think, should be accepted as basic, necessary, and long overdue in today's world. And we know that VAWA will again face reauthorization and potential expiration in 2018. And the topic of this topic of politicization of safety is more relevant than ever, particularly given President Trump's many different actions, including the anti-immigrant executive orders, recent rollbacks of protections for transgender individuals, attacks on legal services, on health care, including reproductive health, and on social services, housing, and poverty reduction programs that are so key to escaping abuse and to ending conditions that exacerbate abuse. We're going to be talking about these topics, I think, really throughout our day today, and then also specifically at the 11 a.m. panel on responses to gender-based violence in the Trump era. And engaging in power mapping, we can consider who holds the power to make decisions that affect the most intimate aspects of our lives. So when I think about the decider, I remember George W. Bush declaring himself the decider. But as the current decider of national policy, the NRA, which spent over $30 million to ensure that President Trump was elected, and wants to get what it paid for. Is it President Trump or Vice President Pence, whose troubling histories of misogyny, sexism, homophobia, xenophobia, and religious prejudice alarm many anti-domestic violence advocates? Is it a majority white male cabinet and Congress, shown here signing the global gag order? Is it the ultimate decider, the Supreme Court? So we have news on that, of course, and what the composition of the Supreme Court in the years and decades ahead certainly matters. While the leaders of our branches of government wield significant power, government actors at the local level also impact interventions in families. So we can think of a child protective service worker who accuses an abuse survivor of failing to protect her children from being exposed to domestic violence, or who mistakes poverty for neglect and removes a child from a nonviolent parent. And of course, you've seen the news of the ICE agent who arrested a domestic violence victim inside the courthouse after her restraining order hearing, and how courthouses are no longer off limits in terms of ICE enforcement. We can examine laws on the books and the forces that motivate them, and how in everyday life, government actors carry out mandates, exercise discretion, and employ state interventions that are helpful or harmful regarding family violence. And we know that the development of current domestic violence policies, of course, has a complex history, and that the way forward will be politically fraught. Our feminist movements of the 1970s were largely led by white middle-class women who were able to prioritize one basis of oppression, their gender, over multiple oppressions of racism, homophobia, poverty, immigration status, and other areas. The gendered, heteronormative, hierarchical state responses to family violence have hindered the development of more survivor-centered or community-based solutions, and have often had the effect of replacing the abuser's control with state control. And scholars have noted the gap between mainstream or elite mediagenic feminist priorities and the daily realities of most survivors in America. The urgent need for intersectionality remains in our gender-based violence responses, and we're going to hear from Kimberly Crenshaw at the end of our day. She'll be arriving and speaking on the urgency of intersectionality later today. And of course, our government-based funding has prioritized criminalization and criminal justice responses. And so we must remember that the Violence Against Women Act was originally part of the Violent Crime Control and Law Enforcement Act of 1994 and a series of tough-on-crime laws. And that VAWA's goal of making law enforcement the primary tool to stop domestic violence has been heavily criticized. And that while our funding has been going towards these criminal efforts, the real needs that people also have in the way of housing and benefits and economic opportunities to move forward have not been as well funded. Today's panelists are an incredible array of movement leaders and scholars and activists. They have experience working with abuse survivors, seeing the law in action, and being part of reform movements, all while engaging in research and scholarship, I'm just excited about the day and what it'll bring in terms of our abilities together to explore the politics and the future of domestic violence responses. So we can consider, what is the future of feminism and the movements against gender-based violence and domestic violence? And this politicization of safety theme invites us to question assumptions about how we do currently and how we should respond to intimate partner violence, and to challenge the domestic violence field to move beyond old paradigms and contend with much larger and broader justice issues. We certainly need nuanced responses. We also need to avoid a failure of the moral imagination that accepts family violence and gender subordination as inevitable. And I hope that we can be both idealistic and pragmatic as we imagine what these movements are and what they can do. So at this point, I'm going to say thank you and welcome, and turn it to Emily, who's going to introduce our other panelists this morning for the first panel.
Good morning. I want to thank Jane for the invitation to moderate this really excellent panel this morning. My name is Emily Zuma. I'm Assistant Professor of Gender and Sexuality Studies and History here at UC Irvine. And I'm going to actually begin with brief bios of both of our panelists in the order in which they will speak. So first we'll hear from Mimi Kim, who is Assistant Professor of Social Work at Cal State Long Beach, where she teaches courses in social work policy and applied social work. She's a longtime anti-domestic violence advocate in Asian immigrant and refugee communities and remains active in the promotion of community organizing, community accountability, and transformative justice approaches to violence intervention and prevention. And her presentation today is titled Decoupling Safety from Crime Control, Current Trends in the Feminist Anti-Violence Movement. And next we'll hear from Deborah Wiseman, who is the Reef C. Ivey II Distinguished Professor of Law at the University of North Carolina School of Law, where she currently teaches the Human Rights Policy Lab, Gender Violence in the Law, and the Lawyer as Public Citizen. In 2013, she received the Frank Porter Graham Award from the North Carolina American Civil Liberties Union for outstanding civil rights work. Her presentation today is titled The Community Politics of Domestic Violence. Please help me in welcoming our panelists.
So I'm going to do a little context setting. So in talking about decoupling safety from crime control, I'm going to do a little bit of a broad sweep of the last 40 years and try to land here in the current time in the approximately, I think, 10 minutes that I was given. What that requires is for me to make some assumptions about some of the terminology I'm using. Some people will be very familiar with carceral feminism. Perhaps everybody will be. There might be a couple of people that are, we would need to stop right there. So I apologize for having to do that kind of quickly, and that I think that when we have Q&A and as we talk through the rest of the day, we'll have time to deconstruct and take apart some of the terminology that might be unfamiliar to you. So with that, I'm going to go ahead and start. You can see the title here. I'm going to be looking broadly at the entire anti-violence movement, but there are times at which I will focus a little bit more specifically on domestic violence as opposed to some of the policy changes in organizations that are around sexual violence. So what I thought, I've never done this before. I actually found this timeline app, and if you look at this, some people are going to feel thrilled because they love timelines and they love something that's jam-packed like this, and some are going to be extremely overwhelmed and horrified. So let's just go through this, and I hope by the end of this, this will make some sense. My guess is right now it doesn't. It's very crowded. I'm going to add on top of that also another visual here, which is the rising rates of U.S. rates of incarceration over the same time period. So the timeline goes from roughly from 1970 till today, and you can see that there's an absolute climb. of the rates of incarceration during the same time. Many of you know this already. For some of you, this might be new information. I also thought I'd start by clearing this timeline, and when I did this, I had such a feeling of, some people might, again, feel cold and alienated. I felt like liberated and like the possibility, and I thought I'd just add something. In this timeline, Prince is still alive. All right, let's just have a moment. The moment's over. Instead, we're going to move to what really happened. Sorry, and Elisa's not here right now, but she'd appreciate that. Anyways, what do we look at when we go back to the early 1970s in this timeline? We see the punitive turn, 1973, and we see a very coincidental timing of the start of the anti-violence movement, the anti-rape movement, the battered women's movement, or the anti-domestic violence movement, right around the same time. If you look at the work of Elizabeth Pleck, I mean, different people might time it differently, but what she says is anti-rape movement roughly 1971, anti-violence movement, anti-domestic violence movement roughly 1973, and that's with a couple of events, the first anti-rape speak out, the first local NOW task force that even named domestic violence, which they called household violence at that time, as an issue. People were not, when they said domestic violence, they actually were not talking about this form of violence at that time. You also see some coincidence between the punitive turn and the Rockefeller drug laws that were passed in New York in 1973. Okay, so we have a coincidental timing right about that time in 1973. And I'll just add a couple more first. We have the first explicitly feminist domestic violence shelter. There are contentions about what's the first shelter, but the first explicitly feminist one in St. Paul in 1974. I'm just going to place in here the start of the first national coalition against domestic violence, which still is alive today in 1978. So these are some markers, particularly with domestic violence. I'm going to jump forward a couple of decades here to VAWA, the Violence Against Women Act that, of course, we all talk about a lot, and that Jane Stover already mentioned this morning. So this act happened in 1994, so it just gives you some idea of the continuum. What some people might not be familiar with is VAWA is often called the first federal act to deal with domestic violence, but actually FIPSVA, 10 years earlier, was passed in 1984 as the first federal act to actually give funding to domestic violence and sexual assault programs. So we could see that there, domestic violence in particular. As many of you know, and as Dr. Stover already mentioned, Violence Against Women Act, VAWA, that we're really fighting to keep right now, actually was a real important turning point in that it was passed as part of the crime bill in 1994. So I don't think I can underestimate how important that was as a time of really concretizing the coupling of the anti-violence movement with crime control, right? And we had a series of other acts that had preceded that, and I'm not going to go into them all, but for example, the passage of the first Three Strikes Law Act in Washington in 1993. Elisa, you missed my Prince is Alive in 2017. I'll show it to you later. The fantasy timeline. What we also see, so I just want to show a little bit of the coupling that already happened, not just only with VAWA as being part of the crime bill in 1994, but if we look 10 years back, and who was president 10 years back? Ronald Reagan. So perhaps it's not surprising that we had a passage of another bill that was not, now FIPSA was passed as part of the Department of Health and Human Services, but VAWA, the Victim of Crime Act, was also highly associated with elevating the victim as a political agent, a central political agent in the US imagination. So we have that happening around the same time as well. You'll see a couple of different institutions that were started by people that were domestic violence social movement advocates in 1980. One is the first victim witness program in San Francisco that brought the social movement into the Hall of Justice, so working hand in hand with the prosecutorial office, right? And we have the first CCR, which is the, the Coordinated Community Response that started in Duluth, which was another way of linking law enforcement that had not previously worked with the anti-violence movement together with domestic violence advocates to say that we have to have a common agenda. So I have a whole other talk on that. Some of you have heard at least once, but that is a key moment there. What happens with some of that? The CCR in Duluth also has a pilot program that is one of the first mandatory arrest programs in 1991. It's local, it's not federal, but it calls attention, the Donovan Show, all these different, Donahue Show, excuse me, all of these TV programs start focusing in on that, saying, mandatory arrest, this might be something that is a really good idea for battered women, but also in terms of other kinds of issues. We have, in 1984, in Minnesota, but in Minneapolis, St. Paul, we have the Minneapolis Experiment on Mandatory Arrest, which is a program that is called successful, but we later know that has had multiple pilot programs in which it was not necessarily successful, but which led to an incredible sweep of mandatory arrest laws passed across the country, statewide and locally. So we have some other countervailing forces. So in the 1980s, a fairly bleak period, if we look at the time of neoliberalism and Reagan, we also have Kimberly Crenshaw coin intersectionality for the first time in 1989, and then with her really landmark article in 1991. And I'm very excited that she's going to be speaking later on to talk about what that means today. We also, and I want to turn towards some of the countervailing forces, which is critical resistance, which is a prison abolitionist event with 2,000 people coming to a conference in Berkeley, but really setting off a prison abolition movement, of course, that had been in the United States for many, 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 many years, but which took on a new contemporary form in 1998. I also want to say in 1997, Angela Davis, who was one of the key proponents of this, of critical resistance, also coined the prison industrial complex, a term we're very familiar with now. We have Insight, an organization that I've been part of, and a few people here, or a couple people here, have been a part of, that started in 2000. That was, I would say, a women of color-led organization. That was one of the first places where we really linked interpersonal violence with state violence in a very, very explicit way. We also have Generation 5 that championed transformative justice as a non-criminalizing way to deal with child sexual abuse. I think that the two organizations together really had a profound effect in actually the introduction of some of the terms that some of you are becoming familiar with now, or maybe very familiar with: community accountability, transformative justice, alternatives to the criminal justice system in terms of many, many issues, but in particular domestic violence, sexual assault, sex trafficking, and so on. Of course, we still have, in terms of crime control, many, many different policies and measures that continue today that strengthen the carceral system. The Patriot Act in 2001, which actually preceded 9/11, but which increased police powers of surveillance and increased the power of what was then known as, not ICE, but as, oh goodness, INS. Thank you. In 2001, there was not frequent use of mass incarceration, a term that we're very familiar with now, but mass imprisonment was sort of a precursor to the common use of the term that we use now, mass incarceration, brought in by an edited volume by David Garland. And I just want to show that there was really a kind of a blossoming of a lot of different organizational forms across the country, primarily in marginalized communities, if we want to call it that, communities of color, queer communities, immigrant communities, the intersections of those communities that really looked at alternatives. We cannot, and had really identified something that would later on be called carceral feminism, but had identified the ways in which the mainstream movement had not served and in fact had been very detrimental to our communities. You see CARA, and I want to just point out Elisa is the founder of CARA, that actually predated Insight in Generation 5 in 1999. We have Creative Interventions, an organization that I helped to found, and Philly Stands Up in 2004. We have Audre Lorde Project that started a particular project called SOS, or Safe Outside the System, that worked with countering anti-queer and anti-trans violence in Brooklyn and surrounding areas by mobilizing community members, including small businesses, to actually challenge those forms of violence without referring to the police. Oh, okay. In 2005, Bernstein coins the term carceral feminism that we're now quite familiar with. And I just want to say, moving towards the mainstream movement, and I have 1 minute left, I just wanted to give credit to the National, oops, I'm going to go back to that. The National Co, if you look back in 1978, let's see, what happened here? Oh, I did the second generation of these other movements with a key event of Trayvon Martin killed, as everybody knows, in 2012, but also the launching of the Black Lives Matter movement. The same year, Free Marissa movement started when Marissa Alexander, right, was charged with aggravated assault with a deadly weapon and was going to be put away for 20 years, also launching the Free Marissa movement. So I want to show some of the most recent entries into what we might call counter-hegemonic spaces, which is Say Her Name in 2015, and Survived and Punished, which came out of the Free Marissa movement and other movements, and is celebrating its first anniversary, not today, but very, very recently, and started in 2016. The mainstream movement, we had, I want to give credit to Sue Ostoff, who started the National Clearinghouse for the Defense of Battered Women in response to the fact that so many women had been incarcerated and continue to be incarcerated for self-defense. And I want to show that I would say it's just really in the last several years that there has really been a shift in the mainstream movement. In 2014, there was a conference called Converge that really brought together both academics, but also those people working in grassroots movement who were coming up with counter-hegemonic strategies and ways of thinking. And in California in 2016, there was a conference called Shifting the Lens that really highlighted the ways in which mainstream movements have criminalized domestic violence and contributed to mass incarceration, but also the ways in which we are challenging that. So that is my contextual timeline. Now that you see the whole thing, I'm sure you're like, that completely makes sense. And you're no longer feeling overwhelmed. I am, but with the fact that my time is ending, I just want to say that we have built a hegemonic formation of mass incarceration, and that has been built in relationship with carceral feminism. We have also had ways in which there have been other formations that have been building, primarily led by people of color, by queer people of color, by immigrant people of color, and other marginalized communities. And these are some of those organizations, in addition to the ones that I already mentioned, and working to take down carceral feminism. So I had some, if we want to call carceral feminism, and I just looked at this, we have to ask ourselves if this is tectonic shifts, whether we are in a transform plate boundary movement, a divergent plate boundary movement, or a convergent plate boundary movement, or if it's just a lot of steam. So I wanted to end with some points, but I'm going to have to end there, and I could bring them up in the Q&A. Thank you very much.
Good morning, everyone. Mimi said that she had the privilege and challenge of being the first speaker. I have the privilege and absolute benefit for following her, because she has laid out in some of the most impressive, broad, theoretical, graphic strokes the issue that I think we're here to discuss today, the politicization of safety. I'm so grateful to the organizers of this conference. Jane, I know how much work this must have taken to pull us together, and I know how much I'm going to benefit and have benefited from the people who contribute to this discourse and the people who will contribute today through Q&A, so thank you very much. So I'm going to drill down to a very specific case incident and really, I think, show another manifestation of this sort of countervailing tendencies with regard to gender violence. My remarks, again, focus on a very specific incident that occurred between the sheriff of San Francisco and his wife that resulted in criminal charges, charges of official misconduct, and efforts to remove the sheriff from his office for acts that were deemed to constitute domestic violence. So I'll jump right in and tell you about the facts of the case. In December 2011, Ross Mercarimi and Eliana Lopez, husband and wife, were in an argument. Mercarimi had just been elected sheriff to San Francisco, and he was elected with the support of blacks and Latinos and the LGBTQ community, environmental justice people, labor activists, and other social progressive groups. Lopez was and is a successful actor whose performances were best known in her home country of Venezuela. And the specifics of what ensued between the couple are not contested. During the argument on their way to lunch, Mercarimi refused to stop the family car. Their child was in the back seat. He turned around and went home. And when Lopez went to exit the car, he grabbed her arm to try to keep her from exiting, and he left a bruise on her arm. Their relationship had grown tense over the past several months, and they were arguing about the possibility of separating and custody issues. The next day, Lopez went to see her neighbor, Ivory Madison, who was a lawyer, and what transpired between Lopez and Madison is very much in dispute. Lopez states that she sought custody advice from Madison, who she knew to be a lawyer, recounted to her the day's prior argument and showed her the bruise. And Madison advised her that in a custody suit, she would be at a disadvantage because she was an immigrant, a fact that Lopez believed to be true, given what she had heard about custody determinations that are adverse to immigrant parents. At the time, she did not yet have her green card. She had a conditional green card. Madison told her to make a video documenting the bruise in the eventuality of a custody dispute, and Lopez agreed, reluctantly, but agreed to make the video, did so understanding that it was protected by, it was confidential and protected by attorney-client privilege, and was only to be used in the eventuality of a custody dispute. Madison differs on that account. She says she is an attorney, but not licensed to practice law in disputes that she ever held herself out as such. The events following the making of the video are also in dispute, although Madison admits that Lopez told her a few days after the event that things had improved, that Lopez was in no fear of Mercarimi. She discussed with Lopez whether Lopez should call the police, and Lopez declined to do so. And Lopez explained that they had decided she and Mercarimi would seek counseling, and that Mercarimi had apologized for his actions. Again, going back to what is not in dispute, is that 4 days after making the video, without permission from Lopez, Madison, whose husbands and close associates were adversaries to this progressive sheriff in the context of the issues that I described, called the police. And the police learned from Madison that she had a video of Lopez's bruise, and they confiscated it. An officer who arrived shortly thereafter determined that, or confirmed that Lopez had repeatedly denied being in fear, being in danger, wanting police intervention, and insisted that the video was taken out of context. Based on the call from Madison and the video, the district attorney's office determined to file charges against Mercouriemi and obtained an emergency protective order barring Mercouriemi from having any contact with Lopez or their son. All of this without the district attorney's office ever having spoken one word to Lopez. At the arraignment, the district attorney's office sought to extend the protection order, and Lopez objected, and she appeared for the purposes of asking the order to be dissolved. Prior to hearing any testimony, Susan Briel, the judge in the matter, stated that she was inclined to issue a stay-away order, and so I'm going to read you an excerpt from the transcript of the arraignment. She says, "I understand from what I read in the newspaper, and that's how I get a lot of my information, that Ms. Lopez has only been in the country a couple of years. She's an immigrant to this country. She came here without the support of a mother, a father, a brother, a sister, or family member." And she also made reference to the fact that she thought Lopez didn't speak much English. Referring to Lopez as the complaining witness, although she was not, Judge Briel allowed Lopez to speak, but only in open court, despite Lopez's request for an in-camera hearing to preserve her privacy. When finally provided the opportunity to speak, Lopez said, "I want to say this picture, that the little poor immigrant is a little insulting. I feel like in a city like San Francisco, highly diversity is a little racism. And I want to say I am 36 years old. I am being independent since I am 20 years old. I've been living in Mexico for 1 year working. I was living in London. I've been traveling. I was in Tibet for 2 months. I was in Europe traveling for 2 months. I've been traveling all around Latin America. I can explain myself. I'm able to speak and understand everything is happening here. And yes, I think that there is violence against me. I think I don't have my family together. I'm not afraid of my husband at all. I'm not in danger. The country's trying to pull me apart. This is the real violence I'm living." The assistant district attorney declined to examine Lopez. She acknowledged that Lopez did not want the stay-away order and was not in fear. Nonetheless, she argued that Lopez was a reluctant or minimizing victim. The next hearing, the pretrial hearing, included expert testimony from a domestic violence scholar who had never spoken with Lopez. And at that point, Mercouriemi determined that he would plead guilty to false imprisonment. And Lopez and Mercouriemi both explained that the plea was the only way the family could be reunited, and the pressure of their legally mandated separation and the spiraling legal costs was more they can bear. 2 days after Mercouriemi pled guilty, the mayor of San Francisco, a political adversary of the sheriff, suspended him without pay and initiated proceedings to remove him from office. The charges were heard in public hearings before the city's Ethics Commission over the course of 8 months, and a full-day hearing subsequent to that before the Board of Supervisors. And at the end of nearly each hearing, public commentary was provided by the interested residents of the city. Nearly all of the commentary was in favor of reinstating Mercouriemi to the office of sheriff. Theories of victimhood incorporate several complicated factors: recognition of harm, the identification of the victim, often through the lens of identity politics, and an imperative to act, including rescue and repair and punishment. And these factors shape the law that follows. Marie Gottschalk has observed that victims have become a powerful weapon in the arsenal of proponents of the law and order agenda. Their needs are determined by those who presume to know or share their circumstances. And a particularized construct of victimhood has emerged, and that is the domestic violence victim. Eliana Lopez was proclaimed a victim of domestic violence by a neighbor, by the police, by the judge, by the mayor, by the officials of city government. She was their victim. They possessed the authority to decide whether and how to proceed. She had none. Victimhood was established by a domestic violence scholar who appeared as an expert who had never met her, who relied on a one-size-fits-all victim-perpetrator profile, and also relied on debunked theories about domestic violence. Lopez's victimhood was embellished through racialized assumptions. Her immigrant status and her lack of English language proficiency were evidence of her helplessness and the cause of her inability to recognize her own victimhood. Her view of her own circumstances was discredited in favor of an institutional response by those who know better. It is not only the criminal justice actors who exploited victimhood. Lopez was denied agency by many domestic violence advocates. This was no private matter, domestic violence advocates exclaimed in public and on billboards that they purchased for the purposes of this campaign against Mercouriemi. Domestic violence advocates organized a rally at City Hall in defense of Lopez's interests and vowed they would do everything they could to keep her safe. The organizer of the rally, the executive director of the Domestic Violence Consortium, introduced members of the domestic violence community who were present. Ironically, she failed to acknowledge the presence of Lopez because neither she nor other members of the Domestic Violence Alliance knew who she was and did not recognize her. But that seemed to not matter. If Lopez declined the offer of assistance, her victimhood was no longer important. A new narrative emerged. The Mercurini case is an anomaly, as one domestic violence advocate noted after referring to Lopez as a survivor, one in which domestic violence advocates are not involved on behalf of the survivor, usually our only priority, but rather as caretakers of a system-wide protection on behalf of the entire community's safety. Lopez served as the means by which the domestic violence movement would make its claim to keep the community safe, according to its norms and values associated with the criminal justice system. Domestic violence advocates invoke zero tolerance, but I would argue that such framing restricts critical thinking about domestic violence and has resulted in an intolerance to consider differentiated concepts of physical violence that would require differentiated responses, including non-criminal consequences. But it's the public commentary offered throughout the Mercurini-Lopez case that I think is perhaps the most significant aspect of this case. Residents who spoke at the hearing provided a critical assessment of the criminal justice response to domestic violence and sharp criticisms of the mainstream domestic violence movement whose members championed such response. Public commentators questioned the very definition of domestic violence for failing to consider the complexities of intimate partner dynamics and critiqued the lack of proportionate responses to the distinct forms that such acts may take. Most commentators urged that other forms of social violence, including police abuse, environmental degradation, and xenophobia, be addressed as a way to strengthen the fabric of families and communities. Mercurini supporters criticized law enforcement, city officials, and domestic violence responses as consistent with the predilections of the carceral state. They called it a political maneuver, a coup d'etat, and a mechanism of voter disenfranchisement. Domestic violence advocates, however, urged city officials to remove Mercurini. The paradigm of domestic violence, they insisted, allowed little nuance. What had occurred between Lopez and Mercurini, they argued, was an act of domestic violence to which the criminal justice system was obliged to respond. Community members responded, this was a political power play to which the domestic violence community lent their credibility. Domestic violence were viewed as manipulative, self-serving, and allied with the powerful. To Mercurini's supporters, his prosecution for domestic violence had little to do with the well-being of women. This was, to borrow a phrase from Naomi Wolf, feminism's appropriation for less than feminist purposes. The comments reflected the extent to which the tethering of the mainstream domestic violence movement to systems of punishment were determined to be discordant with progressive social norms and were particularly at odds with the interests of those who have suffered the racist reach of the carceral state. Residents stated concern about the over-inclusive definition of domestic violence as a criminal matter. Many argued that an armed grab did not constitute domestic violence and was nothing exceptional in the realm of family arguments, that it was an unfortunate but commonplace event that took place in a heated dispute between couples that did not warrant any criminal intervention, not to say that it didn't warrant intervention, but not any criminal intervention. And these viewpoints are consistent with the studies of sociologists who offer more nuanced definitions of domestic abuse and recognize that some forms of violence in relationships are neither abusive nor warrant legal intervention, while others may be so destructive and require criminal sanctions. City residents also objected to the nature of the consequences that Mercurini suffered as a result of having been charged with domestic violence. They called for a more nuanced approach with an emphasis on restorative justice. Community members despaired over the fact that Mercurini was not allowed to see his wife or his child, deprived of his pay while suspended, and argued that removing him from office was disproportionate to the offense. They objected to the ways in which domestic violence advocates who spoke against Mercurini exploited the construct of victimhood. I feel offended by the domestic violence advocates exploiting a family crisis for their own agenda, stated one woman commentator, which has nothing to do with protecting victims. All in all, over 90% of those who gave public commentary supported Mercurini, and it should be added Lopez. I read through the transcripts of every hearing, and I watched the videos of every hearing, and I can say with certainty that the overwhelming number of people who spoke on his behalf were poor people with prior contact with the criminal justice system and or people of color, immigrants. San Francisco residents who spoke in support of McGreamy reflected similar interests as new social movement actors such as Black Lives Matter and Say Her Name have addressed the deep roots of racism and the historic relationship of the criminal justice system to injustice. Their critique not only addressed procedural fairness, but focused on the substantive deficiencies of the laws directed at domestic violence and revealed a deepening breach between mainstream domestic violence advocates and the social justice movement. After the hearing, Lopez wrote and performed a one-woman bilingual play about her ordeal, entitled, What is the Scandal? ¿Cuál es el escándalo? Lopez sent out invitations to leaders of the mainstream domestic violence agencies to attend the play. They did not respond, and to the best of her knowledge, have not attended any of her performances. So time's up, but I'm happy to discuss options and alternatives in the Q&A. I think there have been so many options and alternatives to the marriage between the domestic violence movement and the carceral state. And it's not for a lack of imagination and ideas, it's really a lack of political will. Thank you.
Thank you so much to all of our speakers so far this morning. I also have a difficult task because we're out of time, we're over time. So we unfortunately won't be able to have a Q&A right now, but I'm just going to raise a couple of quick comments and questions that hopefully we can take up on the breaks today and pursue in the other discussions to come. I want to say to start that I think both of these presentations have given us such complementary, such devastating, and such important ways into this quagmire of how the anti-domestic violence movement interacts with the carceral state. So as Mimi Kim laid out for us, this kind of incredible, comprehensive timeline to really demonstrate these different moments of co-constitutiveness between the buildup of the prison industrial complex and anti-domestic violence policy. And then we have this very recent snapshot of a particular case that shows us the lack of trust, the lack of relationship between some segments of the anti-violence movement and racial justice movements. I say some because I think what we see in Mimi's timeline is the significance and the importance that there are other moments where there are cross-movement conversations happening. How do we scale those up? How do we really sort of look to those moments where coalitions have already been built? How do we build more political will, as Deborah said, to really amplify those kinds of connections that are being made? And I guess one thing that comes up for me when I listen to these two papers is really the question that Jane raised about what's on the horizon with the 2018 Violence Against Women Act reauthorization and the legislative battle that is sure to come. And so I suppose one question I'll put in the room before we break is just simply what are the lessons we might take from these presenters' comments this morning about how to engage in that legislative battle, how to not only have a defensive position to defend VAWA as is, to defend it from being gutted, but to, as Jane mentioned earlier, sort of question our own assumptions, move beyond old paradigms, directly confront the contradictions of carceral feminism. Thank you so much.